Hello, everyone. I am here to talk about Injustice Incorporated, which is a book that Amnesty International published in March of this year. I'm aware that there are people in the audience who have heard about Injustice Incorporated before. So what I'd like to do in this discussion is really pull out some of the key points, that will add to the points that Robert has made. As well as I hope to set the agenda, as we move forward, in the next couple of years. So Injustice Incorporated, we do have copies that are available if people would like some. Essentially, the reason why we set out to do this book changed a little bit, I suppose. In the beginning, it really was to document the obstacles to victims' ability to access a remedy. And as time went on, it wasn't just about documenting the obstacles. It was basically proving the fact that actually the policies and the laws as they currently exist, they aren't working. The laws are not working in the interests of victims, particularly when they're foreign victims, but also when they are domestic victims, of corporate human rights abuses. So with that in mind, we decided to use the 4 cases that are looked at in depth in this study to basically pursue an in-depth analysis of 3 obstacles in particular, but also to try to encourage that all of us actually, what we need to do is we need to change the way that we think and we approach these problems. Especially here in the UK, as we all know, there have been more and more challenges that have been brought into play in terms of bringing cases to represent people who are often the most marginalized, people who are often the most poor, yet people who are often the most affected by corporate violations. So what I'd like to, I'm just highlighting the fact that we have had some discussions on some of the proposals that have been put forward in the book before, and sometimes the response we've received is, oh, it's a good idea, but that'll never happen, or that's a good idea, but there's a bit of a block in terms of how we could actually take forward some of these good ideas. So what we'd like to do is actually encourage, more targeted discussions where we can actually look at, if at least 1 or 2 of these good ideas can be taken forward, what does that look like? What other areas of law can we draw from? For example, corruption has been put forward a lot. Money laundering. Different areas where there's other corporate sort of malfeasance, where there have been gains that have been made, and perhaps in the human rights domain, since we are talking about corporations, it's really about looking at, well, what can be transferred from these other areas so that we can maybe redefine or rethink about how we move forward the corporate abuse and right to remedy debate. So in the book, we essentially look at 4 case studies. So those 4 case studies that we look at, all 4 of them, well, 3 of the 4 are quite historical in the sense that, one of them is the 1984 Bhopal gas leak in India, which I'm sure everyone in this room is aware of. Even though it was in 1984, we're in 2014, Bhopal has still not been cleaned up. And there have been a series of attempts at legal actions. However, most, if not all, have been unsuccessful. There was a settlement that was reached in the early days, but the settlement was clearly inadequate, to the harm that was actually suffered by the people. It's an interesting case because this year actually also marks the 30th anniversary of the disaster itself. But today there are still ongoing violations. The place is environmentally contaminated, which affects people's human rights. The right to health being the right to water, all very essential ones. It's also a place where we've seen intergenerational impacts. So, there's evidence and there's information about, young people, this is where they're born, this is where they've grown up, and you can see impacts on these individuals. What's interesting is that there's never actually been an official government-sponsored health study, of this area and of the impacts on people. There have been civil society groups that have taken it upon themselves to try and document the health consequences. But these types of situations, they have to change. There has to be a realization that, I mean, the role of governments, which we're all very clear on, but there needs to be more targeted action to making sure governments fulfill their role, but also companies. They have to also be brought into the solution picture rather than often being given an easier way out of, in that example, enter a settlement agreement and then the company pays some money and then washes their hands and walks away. I think that model in itself needs to be questioned, the ability of these settlement agreements to happen without a full account of the different aspects of redress and remedy being brought into play. Another case study that we look at focuses on a gold mine in Guyana where a waste containment system failed in August 1995. And as a result, it flooded a river with hazardous materials causing serious harm to local livelihoods. It's also an instance where the contamination has never been properly cleaned up. So it's also an environment and contamination related case. The third case that we look at is the Oktedi mine in Papua New Guinea, which also involved the failure of a mine waste containment system. And that resulted in the flooding of local rivers with harmful waste. The initial event happened in 1984. However, again in 2014, there still has been no cleanup. And arguably, there's still evidence of ongoing violations to people and to the environment and to people's right to health. The fourth case study that's looked at is the dumping of toxic waste in Abidjan in Côte d'Ivoire in 2006, which resulted in more than 100,000 people seeking medical treatment. And there was some decontamination in Côte d'Ivoire. Interestingly enough, currently, there is, an independent assessment that is planned to basically confirm the extent of the decontamination and whether or not there are any lingering health effects. So we're going back 30 years in one case. We're going back at least 8 years in the most recent case that's been cited in this book. Why these cases? Because they're emblematic of several attempts that have been made by people who have been affected to obtain a legal remedy. So to access a court either in the host jurisdiction, the place where the harm occurred, or in the home jurisdiction. And as we're all aware, the ability to access courts is an important part of remedy, but it's not the only aspect of remedy. Remedy includes the equal and effective rights to access justice, adequate, effective, and prompt reparation for the harm that's been suffered, and access to relevant information, which Robert spoke about with respect to the violation as well as the reparation mechanisms. So I'm not going to go into any more detail on the cases themselves. I encourage you to read the book. I'll speak about conclusions that we essentially draw on in the book itself. So three of the main obstacles that we analyze the cases, or these four main cases, as well as other cases that Amnesty has conducted research on, include legal hurdles to extraterritorial or transnational legal action, as Robert prefers. The second obstacle relates to victims' lack of information, in particular due to corporate control over information. And the third obstacle relates to the corporate-state relationship. So in this area, we examine the impact of the corporate-state relationship on the willingness and ability of states, how it affects the willingness and ability of states to uphold human rights, including the right to remedy. The focus of the book itself, all of the case studies look at multinational companies. The fact that they're multinational companies and very powerful obviously augments the problem that victims face when they're trying to get a remedy. One of the key obstacles that we basically highlight in the book relates to the corporate complexity and how the complexity of the corporate entity causes a fundamental problem. So you do have the fact that these multinational corporations, as everyone knows, are distinct legal entities if they're set up in different countries in the world. And as such, corporate laws or national laws will recognize that they are distinct legal entities. This in itself, when we look at, we draw a conclusion if we look at where we are now, in terms of international standards on business and human rights, there's a disconnect, because we're all aware of John Ruggie, and under pillar number 2 we have the corporate responsibility to respect, which essentially says that companies have they should be carrying out due diligence, which basically means taking steps to ensure that they're not causing or contributing to human rights abuses in their operations. And their operations are recognized as being multinational in nature. So they're not actually jurisdictionally restricted, they're recognized as being as global. So there is a disconnect between where we are in terms of our international policy position and how laws are at the state level. So in moving forward, it's obvious that this disconnect needs to be addressed. So then the question becomes, well, how do we address this disconnect? So the proposals that we actually have put forward, we've got 2 that we've put forward, and one of them is to, I think Robert referenced this a little bit, is to make the parent or controlling company legally responsible for the human rights abuses arising in their global operations. So this includes human rights abuses committed by subsidiaries. It's an interesting one, and so essentially it's premised on a duty of care. So essentially the parent company is owing a duty of care to the victims. And I believe Sandra is going to speak later on about a law in France that's being put forward that actually proposes, a duty of care concept. We've got a few aspects of it. So a second part of this duty of care that the parent company should have involves or puts forward the idea that in certain situations of large-scale human rights disasters, or where there's serious or systemic human rights abuses arising within the context of global operations, that there should be a rebuttable presumption that the relevant parent company is legally responsible. So what do we mean? So we essentially mean that, well, in cases like Bhopal, and in cases like the Ivory Coast, where it was pretty much unquestionable that this was an industrial disaster, and that people, they suffered, that there actually should be a presumption of liability on the parent company. And this presumption of liability can be rebutted, and perhaps rebutted according to, a standard of care which reflects an international or human rights due diligence standard of care. So it's one concept that we'd be interested in seeing taken up. We've seen other areas. I've used the example of an incidents such as Bhopal, or such as the toxic waste dumping in Ivory Coast. But the truth is, on one hand we think, well, there were mechanisms that were set up, for example, in the United States after the BP Gulf spill, which enabled the victims or people who were affected to be able to claim their remedy. So there were mechanisms that were put in place to basically facilitate that. Why don't we have these mechanisms emerging within these other contexts? It shouldn't be a question of location, as to where the actual damage has occurred. We've also seen within the UK, I think it's very interesting, the revised, or the UK Bribery Act, and this failure to prevent provision, which brings strict liability to the parent company if they fail to prevent corruption, within I think it's accessories or those acting on their behalf. It's very broadly defined. Just very quickly, because I've got 2 minutes. The other proposal that we essentially put forward relate to increased access to relevant information. There's basically, as we know, having information is having power. So if you don't have the information, your power is decreased. Essentially, two reforms that we suggest is one is the mandatory disclosure requirements on companies, which relates to the human rights due diligence that was referred to by Robert, and the second reforms relate to civil procedure rules or disclosure rules. I know it's not so much an issue here in the UK, but in certain jurisdictions, they're very narrowly interpreted. The third sort of area, which I'm happy to speak more of and maybe in the question and answer, is to come up with legal proposals that actually reduce the corporate influence on the state. So this essentially, these proposals look at, one, acknowledging the political and economic power that corporates have over governments, and 2, designing laws that actually add more transparency and disclosure to, 1, the lobbying that companies engage with governments, even if it's informal meetings. And at a second level, it essentially talks about these agreements, or suggests that there are agreements such as pre-investment agreements or sort of land acquisition agreements, that when these agreements are essentially rendered between countries and companies, that there be some requirements that they'd be assessed. 1, they'd be disclosed, transparent, but on a second level, that they'd be assessed from a human rights perspective before they're actually concluded. So I'm going to stop there, and I look forward to the questions. Thank you.
Thanks very much.